Good day. I'm Gerald Goldfarb, and this is the television discussion program Inside Law. Thank you for being with us today. What we try to do on this program, as regular viewers know, is give the public a sort of inside view of how the legal system works. If you watch LA Law, you see kind of a fictionalized view, and we try to show you the reality of the system. I'm a lawyer in private practice in Los Angeles, and I'm very happy to have as my special guest today John Steiner. John, welcome to our program.
Thank you, Jerry.
John is an experienced lawyer and a very knowledgeable man, particularly in the field of criminal defense and particularly in the field of criminal appeals. John, for 5 years, was the chief assistant state public defender in Los Angeles, which means he ran a rather large office handling many criminal appeals. He's published many articles in the field of criminal law. He's a member of the esteemed California Academy of Appellate Lawyers. He's handled 9 or 10 cases in front of the Supreme Court of the state of California. And now he's, for the last couple of years, he's moved over to the world of private practice, and he's a partner in the law firm of Steiner and Gerstein. John, I'd like to begin our conversation today perhaps with something of an overview on criminal appeals. I don't know if people really know what a criminal appeal is. Could you give us a bit of a summary of that?
Sure. When someone is convicted of a crime, and we're talking now particularly in Superior Court, as an example, they have a right to an appeal before the Court of Appeal. There are 6 district courts of appeal in California. A number of the courts of appeal have divisions within the districts. What happens basically is that the individual, if he wants or she wants to appeal, they file a notice of appeal. If they have retained counsel, then counsel can file a notice of appeal for them. And if they don't, then they file it in their own names. And then if they don't have money to hire a lawyer, the court will appoint a lawyer to represent them.
I mean, most criminals are indigent, aren't they? And most criminal appeals are financed by the taxpayer, is that right?
I would say, I'm not sure exactly what the percentages are, but certainly a large number are. Yes, that's right.
Mm-hmm. And I think that that a lot of people have the impression that a good many criminals sort of get off through the appeals process. The law is filled with technicalities, people imagine, and clever lawyers take advantage of them, and criminals get to walk. Could you give some comment on that? Is that accurate perception?
Well, no, I think it isn't at all. If the role of a really clever lawyer, in terms of, I think, the way that word is normally understood, is the lawyer in the trial court who is attempting to prevent the defendant, in this case, from being convicted. Once you get to the Court of Appeal, you're dealing with basically briefs. The appellant or the defendant files an opening brief. The respondent, who was the state of California, is represented by the Attorney General's office, and they have a huge staff in their criminal division, which in effect does nothing else but represent the state in criminal appeals. Then the appellant's lawyer has a chance to file a reply brief, and those are the documents on which the appeal is decided. So the appellate practice, the appellate process is really based on the research into the law that is raised by the issues in the case, and the writing of the lawyer and the way the lawyer presents it to the Court of Appeals.
So there's no new evidence allowed on appeals?
No new evidence allowed. I mean, you're completely restricted to the 4 corners of the transcripts which are prepared from the trial.
Mm-hmm. And what do the statistics show? How often do the criminal defendants win on appeal?
Very infrequently. The statistics for the fiscal year 1985-86 show that roughly 93% of all criminal appeals are affirmed by the Court of Appeal, and somewheres in the area of 7% involve any kind of a reversal. Now let me make it clear that in the vast majority of cases which are reversed, they are simply reversed to go back for a retrial. The court determines that the defendant has not had a fair trial, perhaps due to improper instructions to the jury by the trial court, perhaps due to misconduct by the jury or perhaps the prosecutor, perhaps due to extremely prejudicial evidence which was admitted against the defendant.
So even those 7% who get a reversal, they're not going to walk, they get a new trial, and most of them are going to be convicted again.
That's correct.
I see. So there's a large process that goes on, but the end result is very few people slip out on the appeal process.
That's right. There was an article written several years ago by two law professors who looked at what the statistics showed. And the statistics were very clear that the name of the game in the Court of Appeal is to affirm criminal convictions, in fact to affirm most civil judgments as well. But so any perception that the public might have that somehow criminals people who have been convicted of crime are somehow being let loose en masse by the Court of Appeal is totally unjustified. It just simply is wrong.
Now, the Court of Appeal, when you have an appeal, I believe your case is reviewed by a 3-judge panel who decide whether to uphold it or not. Do these judges actually study the case in detail? I know there's an awful lot of business in the Court of Appeal. There's a lot of criminal cases and civil cases as well going up there. And I've had clients ask me, well, do they really understand the case? How does that work as a practical matter?
Well, it depends upon the judges, and it depends upon the division of the courts that you're assigned to. There's no question that I think of the 3-member panel, certain of the members of the panel may not in fact read the briefs themselves. What happens is after the briefs which I described earlier are filed, in most cases they will be assigned to a research attorney who will research the law, perhaps prepare a draft opinion. In certain situations the judges do that themselves, and then basically one judge has the responsibility for preparing the opinion in the case, and then a draft opinion will be circulated amongst the other panel members, and usually when you appear for oral argument, which is the next stage after the briefing process in the handling of an appeal, you may often see members of the court leafing through a document while they're either listening to counsel argue or ask questions, and often that in fact will be the draft opinion that's been prepared already by either one of the research attorneys or one of the judges themselves.
I see. Well, it's an interesting process, and you've been a close observer of the criminal law for at least 15 years. In terms of an overview, John, what changes have happened in the criminal law over the last 15 years? I think there have been a lot. How's the pendulum been swinging in these years?
Well, I think for a time the courts were more concerned with the constitutional rights of people accused of crime. In fact, the pendulum has swung quite strongly in the opposite direction, and both trial courts and courts of appeal are paying much less attention to the question of whether the evidence was gathered properly or whether any of the rights of the defendant were violated in a way that would cause the defendant to have a fair trial. I'm not saying that just simply, for example, some clients will come into me and have said, well, they didn't tell me my rights. They didn't say I didn't have to make a statement. I will ask them, well, did you make a statement? They say, well, no. And consequently, the failure to read the rights really has no bearing on the case. So we're not talking about meaningless situations. We're talking about situations where, for example, particularly heavy-handed and arguably clearly illegal methods, for example, of interrogation were used in order to get a statement or a confession from the defendant. But anyway, just to go back to the question, I think the courts have tended to swing much more in the right, in the way of, as I said before, upholding and affirming the convictions of defendant in most situations, regardless what types of error have been committed.
Is this a case of the courts just sort of paying attention to the election returns, at least on a subconscious level?
I think it certainly is. I mean, that's one aspect of it, yes. The courts are certainly aware of the public's concern and legitimate concern with the question of crime today and how it affects them and how it affects their daily lives. So there's no question that the court is concerned with that.
I mean, I think one of the best examples of this sort of shift, the ebb and flow of the criminal law, is the way the death penalty is treated. When I was 10 years ago or so, it seems to me the California Supreme Court threw out the death penalty. Justice Wright was the Chief Justice then. He was a Reagan appointee, actually. And then we had the Rose Bird Court. The death penalty was revived by the legislature and by the people in amendments to the Constitution, I guess. And the Bird Court wouldn't enforce the death penalty, and then the election returns came in, and we have a new Supreme Court now which is inclined to uphold the death penalty. Are we going to be seeing executions in California soon, John?
I think it's very likely. I think it's certainly possible, and I think very likely. The court, as it stands so far in the death penalty cases that it's heard, has affirmed I think 4 or 5 cases at this point, and has reversed either only the death sentence, not the conviction, in 2 others. So I think it is likely, certainly, that the court is, the present court is going to affirm many more, probably most convictions.
And there's a lot of these death cases in the pipeline. How many people, right now in the state of California, how many people stand convicted of a death penalty crime?
Well, the way the situation is right now, there are somewhere over 50 cases which have been briefed and argued before the court and are awaiting decision. There are also, to my knowledge, over 100 cases which have not yet been fully briefed or argued before the court, and that there are also somewhere in the area of 2 to 3 death judgments per month coming down throughout the state of California. I'd just like to make one comment in regard to one of the things that you said earlier, which is that I don't think there's really been a question of enforcing the death penalty or not enforcing the death penalty. The courts have always looked to the questions of whether the individual defendant in that particular case got a fair trial. So I don't think it's really a question of enforcing or not enforcing. It's a question of, I think, the attitudes of the different judges in terms of what may or may not constitute reversible error in the proceedings that were held before the trial court.
Well, I don't know if I agree with that entirely, but in any event, it seems like we will fairly soon begin to have executions in this state, and if we do, we could have as many as, I don't know, to clear up the backlog, we could have an execution every week in this state for a few years. That seems to be an incredibly gruesome thing to happen.
Well, I think if that happens, and it is possible, perhaps not necessarily with the frequency that you're talking about, but I mean, I think there is the potential of a really substantial number of executions taking place, and it's my hope that if that happens, people will really begin to become aware of, in fact, that there are executions going on in the state. I think it may be that until something like that happens, people will continue to be concerned with making sure that as many people as possible, for example, are sentenced to death, and that may change when and if there are a large number of executions in the state of California.
Mm-hmm. What's the form of execution under California law? Is it electrocution?
Gas chamber.
Gas chamber. Mm. Well, we certainly hope that's not going to happen, but it may. The Supreme Court reviews all these death cases directly from the trial court, is that
That's
right?
correct.
And the Supreme Court also handles cases of attorney discipline, doesn't it?
That's correct.
And those cases are increasing as the death penalty cases are increasing. And I know there's a concern among lawyers, and I want to ask you about it, that the Supreme Court, which is supposed to oversee the entire legal system in California, is so bogged down with death cases, each of which has a huge record and are obviously very serious matter, plus attorney discipline, which is, I think, again, at public demand increasing. Does the Supreme Court have enough time to do its main job, which is overseeing the legal system?
Well, I mean, the court itself is very concerned, both with the two questions that you raised in terms of death penalty cases and attorney discipline cases, which they do review in the first instance. There have been a number of proposals to remove those cases from the Supreme Court and perhaps have the Court of Appeal look at them first. In addition, there's been one proposal that a separate Court of Appeal altogether be set up to review death penalty cases before they're passed on to the Supreme Court.
But these proposals have been knocking around for at least 5 years in my recollection, and the law we know moves slowly, and nothing's happened yet, and the Supreme Court is more and more clogged up. Is there any light at the end of the tunnel?
Well, I mean,
I wouldn't want to be on the Supreme Court, frankly, with this kind of a backlog of work that they have.
Well, I mean, obviously you'd have to address that kind of a question to one member of the court who maybe you'll have on your show at one point. But there's no question that the court has a tremendous backlog of work. There are, as I said, a very large number of death penalty cases, which, as you said, generally have extremely lengthy records and usually result in lengthy opinions being written. So there is a problem there. Lawyers are concerned with it. The members of the court are concerned with it. Exactly whether there will be an alternative enacted is not clear.
There's actually sort of an elite commission that's been set up to study this problem, isn't there? That's going to be reporting soon?
That may be, yes.
Yeah. Well, we certainly hope we have some improvements there, because the job of the Supreme Court is a hard one. They need to have, I think, their energies freed up a little bit to do it properly.
Well, let me add something to that. I mean, that you referred to briefly, but maybe it's worth articulating more clearly so that people understand. Very often, courts of appeal, because they're made up of different people and there are different fact situations, will come down with decisions which conflict with each other. And one of the things that you were referring to, and one of the things that has always been one of the major duties of the Supreme Court, is to reconcile cases which conflict. In other words, take one or both or however many there are and write an opinion explaining why one particular view is correct and why the other is not.
So the same law will apply in Northern California as in San Diego County. That's the theory of it, right?
That's the theory of it. Yeah. That's the hope of the way the system would work.
Of course, the federal system doesn't work that way, and it works pretty well.
I mean, theoretically, the United States Supreme Court does review conflicts between the circuits, so that again, whether they have the time and whether they're too backlogged with one case or another from different states, people's opinions would vary. But the theory of the Supreme Court is that amongst its other functions, it does exist to reconcile conflicting cases in the Court of Appeal, both in California and in the Supreme Court.
Well, talking more about the Supreme Court, you're an experienced Supreme Court litigator. I think one area, I'd like to have your take on this, I think one area of the Supreme Court's weakness is that it has not supervised well enough the way the legal system functions procedurally. The public, in my experience, is very irritated at the long delays and procedural awkwardnesses in the system. You think the Supreme Court could show more leadership in that area?
Well, I don't know more leadership, but certainly the court, as I understand it, is attempting to deal with those kinds of problems. They're not easy problems to deal with. I don't mean to be an apologist, but the problems are very complex. They involve trial courts, throughout the counties of California, and the appellate courts as well. So there is a judicial council, a number of the members of which are appointed by the Chief Justice, and which reviews those problems and tries to deal with them, writes rules of court for the state. Again, there's no question that all courts are backlogged, and for whatever reason, there do seem to be an increasing number of cases coming before the courts.
Now, on a related subject, and I know one that you're interested in, as the system has gotten a little sterner and more stringent with criminals over the last few years, or with persons convicted of crime, I know we've had a new sentencing law that's been in effect for a few years now, which seems to be leading to longer sentences. Is the prison and jail system, I believe there's an influx of people in the prison and jail system. Is the prison and jail system equipped to handle these people? How's it doing?
Well, I don't think that anyone would argue that certainly Los Angeles County Jail.
That's a monstrous place, isn't it?
And is
I saw the food they served there once. A client of mine was in the jail, and I was having a meeting, and they brought him a sandwich, and the food was so awful that just the odor of it made me ill.
Well, that's a big problem, and as you can imagine, it's greatly emphasized by the fact that the system is tremendously overcrowded. I mean, there is a federal lawsuit which has jurisdiction over the county jails, and the plaintiffs in the lawsuit and the Superior Court and the entire system is trying to work through some sort of a compromise on an order which the federal court made, so that the county jail system can be made less clogged. I mean, it's tremendously overcrowded, well over 100% of capacity.
Now, and I noticed that the governor has asked for huge amounts of money for capital construction for big new penitentiaries, I think both in the North and Southern California. Are you sympathetic to that request? Do you think we need huge new prisons?
Well, that's a very complex question. Again, the state prison system is vastly overcrowded, well over 100% of capacity throughout the prison system, so that there's a real question in a number of the prisons as to whether the people who are in the prison are being treated in a humane way. No one who sends an individual to prison would expect them to receive a kind of cruel and unusual treatment which the Constitution of both the state and the federal government prohibits.
So you're sympathetic to the view that we need these new prisons?
Well, if in fact the same system which presently exists continues to exist, there is a need in order to make the system treat the men and women in it in a humane fashion, there is a need for larger prisons. Or for more prisons. On the other hand, one of the things that I think is tremendously important is that in the prison system throughout the state, while there are some work programs, there is very little of job training, skill training, anything that the individual can use when he or she gets out of prison, so that in fact when an individual gets out of prison, they can perhaps make a contribution to society rather than simply having been warehoused for a large number of years and without really having been able to do anything for themselves.
Well, certainly warehousing is no answer. That's true, John. I understand what you're saying. I think it's helpful. We're getting near the end of our time, but there's one question I really want to ask you as a lawyer in private practice. You were on the public payroll and doing an excellent job for a good many years. Now you've been on.
Thank you.
Now you're in private practice. It's true, and I wonder if you have a little different take on the legal system from the point of view of a private practitioner as opposed to a state public defender.
Well, certainly it's a very different way of practicing law. You don't draw a salary. You have to pay your bills. You have to pay for your supplies. They're not provided for you. So there is certainly an increasing concern that the cases that you take, the referrals that you get, the clients that you accept, pay what is an adequate sum both for you to handle your practice and for you to live on. And that's certainly a very different approach to representing clients than takes place in a public defender's office.
Mm-hmm. And when you deal with these clients, do you find that they have any particular distress or concern about how the system is treating them, the private clients?
Yes, and actually that really is a good question, because one of the things that I have noted is with the clients that have been referred to me.
John, I'm afraid I have to cut you off now. I just got the signal that we're right near the end of our time, and I think I have to close up. Maybe I'll have to have you back so we can get a proper answer from you on that question.
Which I was so anxious to answer.
Which you're anxious to answer, that's right. Well, I'll hear about it later. I want to thank the audience for being with us on Inside Law today. We've had an interesting interview and discussion with John Steiner. This has been Inside Law. I'm your host, Gerald Goldfarb. If any of you have any questions or comments, you're certainly welcome to share them with us. And we hope you will have such questions and comments, because the legal system is something that all of us as citizens of the state of California need to take part in and need to have some contribution to make. So thank you again, and good day. For further information, please call Inside Law at area code 213-285-8599.